Welcome to Ground Rules, employment law over your coffee break. My name's Pam Howland, and I'm the owner of Idaho Employment Lawyers, and I'm here today with my fellow attorneys, Doug Plass and Jennifer Walridge. And today, in honor of Valentine's Day, we are talking about love in the workplace. We think that this is somewhat of a controversial topic in the sense that we sometimes have clients who say they don't feel like they want to interfere whether or not their employees are engaging in office romance or office relationships. And as employment law attorneys, we have a very different perspective on this because from time to time, we get claims, we get lawsuits that all start when you have consensual workplace romances. So a couple of cases that we've seen over the years, we had one that involved a supervisor dating a subordinate. The supervisor was acting under the belief that he was not her direct supervisor, so he didn't think the policy prohibited him from doing that. And because they were in a clearly consensual relationship at the beginning, he did not think there would be liability that could flow from this relationship. But as sometimes happens, the relationship fell apart. The woman who was the subordinate brought a claim against the supervisor. There were allegations of rape, allegations of assault and battery, allegations of other workplace misconduct, and that blew up into a big lawsuit that we ended up defending. That is just one example of the type of thing that can go wrong when employees engage in office romance. So I think Doug had a couple other examples. We were sitting here thinking through some of the things that we've seen over the years. Doug, what's one that comes to your mind?
Well, one thing has to do with, so this isn't a too much of a power disparity. Well, it does involve, an older male employee or older male coworker who is potentially more powerful than the younger female coworker involved here. But it has to do with kind of the initiation of a relationship. So in the workplace, we spend a lot of time around people that are not our friends and family necessarily, and you can kind of misinterpret signals that are sent. And that's what happened here, where we had a person who thought there was something developing and acted upon it and kind of faced a potential battery claim for doing so. So, anytime you're involved with people's outside lives coming into the workplace or starting in the workplace in that way, there is definitely some risk.
Yeah. And that whole concept of power disparity, I think, is an important one because it's not necessarily illegal to have two people in the workplace dating as long as it's consensual. Not necessarily. We would argue that under the law, always a bad idea when you have a supervisor and a subordinate, just because there could be arguments that the subordinate felt like they were obligated to. It's stricter liability when you're talking about the laws that prohibit discrimination and harassment. But this concept of power disparity is a big one. And a power disparity is basically just a situation where one person has more power than someone else. And if you think of the Me Too movement in the 2016 time period, remember the Hollywood Harvey Weinstein, almost all of those involved an argument of power disparity that this famous producer would give acting gigs or star roles to female actresses so long as they would date him or have sex with him. And that really gave momentum to a nationwide movement to more strictly enforce the laws that prohibit sexual harassment. The EEOC, and just a refresh here, if you're not familiar with that term, but the EEOC is the Equal Employment Opportunity Commission, and that is the federal agency, which you may have seen in the news in recent weeks. That's a separate issue maybe we'll cover for another day. But that agency is charged with implementing our federal laws that prohibit discrimination and harassment. And the EEOC has spent a fair amount of time over the years talking about the role that a power disparity has when it comes to discrimination and harassment. And in the 2016 time period, the EEOC had convened a task force that was entirely aimed at better understanding what was going on in workplaces that led to continued claims of discrimination and harassment. Why, after over 50 years of having Title VII in place, are we still seeing discrimination and harassment in the workplace? And one of the outcomes of that 2016 task force was a set of risk factors that can lead to increased risk of discrimination and harassment. And one area that falls on that chart is anytime you have a workplace that involves people working when you have a power disparity involved. So think anytime you have some superstar performers and others who are not as highly regarded. So we're in a law firm. Law firm is one of the typical areas that got highlighted by the EEOC, talking about if you have like a partner who's a rainmaker, and then you have young associates, big power disparity as to how they're regarded in the firm setup. So that whole power disparity concept is just one of many issues that you can think through as an employer when you're thinking about whether or not you should allow workplace romance and some of the problems that can follow if you're allowing relationships like that to happen.
Yeah, I was just going to throw out as Pam was talking, I was thinking of another example that sort of puts that power disparity and I think the risk of when these kinds of issues arise. And, as a business where there was a supervisor and a subordinate have been going to, like, a lot of business travel, right? So they're traveling together for work on a particular occasion, go out for dinner, drinks are had, supervisor ends up spending the night in subordinate's hotel room, difference in stories as to exactly what happened in that hotel room, but the supervisor admits that he fell asleep in the hotel room overnight, and it was his subordinate's hotel room. After that, there were allegations of, the supervisor tried to get me to go on more, business trips with him, and I didn't want to go. Performance issues are arising because the subordinate is refusing to go on trips, and the employer is perceiving it as her refusing to do her job. Even in a situation like that, where, maybe the facts of what actually happened are not quite as bad as what the, subordinate claims, it just is not a great situation, right? Where you've got someone who's saying, look, I felt like I couldn't do my job the way I need to do my job because my subordinate is asking me to do my supervisor is asking me to do things that I don't want to do. And we see that happen a lot, even with consensual relationships that go south, where after the fact, even if it started out okay, again, performance issues, conduct issues come up, and when they get questioned, and you as the employer legitimately can question those kinds of things, the explanation for those things ends up being something that allegedly is sexual harassment, and then you as the employer are having to figure out what to do with that. So having thought through this in advance and how you want to handle those kinds of situations when they arise, whether you're going to permit romantic relationships in the workplace or not. If you do, what safeguards do you want to have in place to help the employer be aware when that is happening, and how you want to deal with it when they come to your attention. All of those are going to be good things to do because it does come up. We see it happen a lot, and it often can lead to potential liability, even if the employer didn't know anything about it until it was essentially too late.
Yeah, as I was listening to Jennifer, I was thinking about sometimes employers misunderstand the scope of Title VII in her scenario, talking about an outside business trip. Maybe it's an outside social function. Maybe it's a summer picnic or a Christmas party. Sometimes we hear from clients things like, well, it wasn't in the workplace, so that's not covered by our anti-harassment and anti-discrimination policy. And that's not exactly accurate. I mean, many a claim was brought by an employee who had some type of interaction with a coworker or a supervisor at an outside event. And that really isn't the parameter of whether or not something's covered by Title VII. If it impacts the employee's ability to then come to work and do their job, it may well be covered by Title VII, regardless of whether or not whatever happened in the actual workplace. We know that outside events can trigger liability, and we know from some fairly recent guidance in 2024 from the EEOC that even things like social media communications, messaging through social media outside of business hours, even those types of things can trigger workplace liability depending on the facts. A lot of it just comes down to whether or not an employee's made to feel uncomfortable doing their job or not.
Yeah, and the other thing is, I mean, you might be listening and saying, well, what the heck do we do about all this? And I think we're about to get there, and I think that's policies, right? I mean, like whether you allow workplace romances or you don't, or whether you have a social media policy or what you're going to do about that, all that should be spelled out in policies in a way that is clear to both the employee and the employer how these things are handled. And one of those might have something to do with disclosure. So you might have something that's saying that if employees choose to be involved in a romantic relationship with one another, they need to tell you about that. Well, when? How? Is it just one person that decides? Do they both decide? I mean, all those sorts of things are things that you want to think about first. I certainly get why employers don't want to be involved in their off-duty time of their employees. But you got to think these things through because, oftentimes, like Pam was mentioning, these things do go south. And I don't know about you all, but my experience is that when they do go south, at least one person is not happy. and those behaviors that seemed just fine in the workplace a minute ago are now definitely not fine. And, if you're the employer and you have kind of heads up and notice about what's going on, you're in a better position to deal with those.
Yep. Yeah, you might have a situation where a relationship which appears to be going well suddenly unravels and one of those people is unhappy. Or you might have a relationship that's going well, but it's the coworkers who are unhappy. What if you have a situation where you have a dating couple in the workplace and they're saying or doing things that are making their coworkers feel uncomfortable? Maybe there's a perception of favoritism. Maybe there's a perception of a lack of professionalism. All of those things can contribute to the problem. So, Doug's point is a good one. And if you listen to our podcast, you'll probably hear us almost in every episode talk about how important your policies are. It's not that we love writing handbooks or reading policy, but really when things go south, your policies are your defense, at least your best first line of defense, I would say. So how would you know what to put in a policy like this? That's easy to find. The EEOC has guidance. The EEOC has policy guidance. And if you're wondering, what needs to go in an anti-harassment policy, what type of language would I even want to put in a workplace or an office romance policy? There are a lot of resources available for that. And again, start with what the EEOC has put out, because I would imagine, I guess I don't know for sure, but I would imagine that if you're going to track with something that the EEOC has put out, you're going to be in pretty good shape to say that you've got a legally viable, policy that complies with the law. Another possible thing to think about is the concept of love contracts. We were chatting about this a little bit before the podcast started, and over the years, we have been asked from time to time to draft a love contract or two. What is that? It's basically a contract where if you have a couple who is in some type of romantic relationship, it's basically an agreement between the two where they represent that the relationship is consensual and not sexual harassment. It can be a reminder to dating employees that they need to conduct themselves professionally, and it can be a tool for employers so that if things go south at some point, that they can establish they recognize the potential issues and that the employees agreed it was consensual, and that they were in that relationship voluntarily, consensually, and knew the employer's policies around it.
Well, I was going to add that one other piece that I have sometimes seen in love contracts, although not in all of them, is some kind of agreement from the employees as to what may or will happen if the relationship doesn't work out. It's almost like an employer prenuptial agreement that they agree that one or both of them will transfer to a different department, for example. So everyone's on the same page and understands that the relationship could not work out. And if it doesn't, and there's any kind of, animosity or discomfort or, anything that's creating issues in the workplace, that the employees recognize and understand that there could be job-related changes that occur as a result. One other thing, too, is sometimes, even if you already have it in your policies, that the employees will agree to avoid, any physical or overt romantic actions, in the workplace, kind of keeping in mind, again, that you don't want to make your coworkers uncomfortable with the nature of a relationship. You're going to keep it professional and leave your personal relationship outside of work to the same extent that's required of all employees in the workplace. So those are a couple other pieces of that you can include in a love contract that I would say would increase the value of doing it. And really it is just making sure everyone understands what's expected, what's required, you'll follow policies, and again, potentially having some teaser of sorts, a heads up as to what could happen if things don't work out.
I think those are really important points. I think, I'm a little skeptical about love contract, and I'm a lot less skeptical if they have those sorts of things in there. And one thing, we mentioned power disparities earlier. A love contract doesn't defeat any of that, right? So if you have a relationship between a supervisor and an employee, the same arguments about that the lower level employee was not entering into this consensually will still be there, even if you have a signed piece of paper saying that they're not there. I'm getting a little bit of what's the look on your face, Jennifer?
Skepticism, healthy skepticism. No, but I take Doug's point.
I think it helps. It certainly could help, but it's not going to defeat it entirely. I think you still have the power disparity. Doesn't matter what you sign. If you're coerced into signing that, what's worse, to be coerced into signing a piece of paper, or to be coerced into a romantic relationship you don't want? It seems to me that the piece of paper is not that big of a deal compared to the other things. So, yeah.
I will say, in general, it no matter what, to Doug's point, it is going to be higher risk, and I would even argue a risk that you do not want to take, to have anyone in a supervisory disparity to be in a romantic relationship. There may be some employers where, the relationship predated the existence of, the company, for example. So that could be a special case. But in general, it is always going to be better to not allow probably relationships between your supervisors and their subordinates.
And we know that supervisor liability under Title VII is strict. An employer is vicariously liable for a hostile work environment created by a supervisor. And if you have a supervisor who's in a relationship like this and the relationship goes south, you may well face allegations that the supervisor engaged in harassment or discrimination, and it's going to be harder for you to prove that they didn't. The law presumes supervisors to know the law and to basically act professionally. And I think at the heart of it, maybe it comes down to that, is if you have a supervisor who's prioritized their personal life over their professional life in regard to workplace relationships, that can be spun in a way that looks pretty bad and somewhat hard to defend from our perspective. One other issue I was going to touch on. So we had the Doug and Jennifer duke out over the love policies and whether or not they're enforceable. One other concept that comes up when you have workplace relationships is retaliation. And we haven't really touched on that much. Retaliation is any time there's a perception that someone's engaging in some type of protected activity and then they get treated disfavorably via some type of adverse action. Retaliation can be addressed in a love contract. That could be one more provision, that you put in there, something to the effect of, both people recognize that retaliation's not prohibited and it won't be allowed, and this is how we're going to ensure that happens. And that could possibly be an argument for an employer so that if the relationship blows up later and the employee brings some kind of claim, that the employer has a defense to that. So retaliation is always a problem, right? Those claims are easier for an employee to prove than a full-blown discrimination or harassment complaint. And it's easy to imagine scenarios where if you have a workplace relationship, that could give rise to a retaliation claim, right? Like I was dating Joe. Things started to go south, so I went and talked to HR about it. We ended up breaking up, and then Joe became my supervisor, and now suddenly I'm being disciplined. I mean, I think it's easy to think of ways that retaliation can creep into any type of workplace romance. So that's just one more thing to be thinking about. And we would argue one more reason to avoid situations like this, or at least to think through them and think through it from a policy standpoint. So the big takeaways as we close out for today, basically update your policies, do it every year. And if you haven't thought through workplace romance and the extent to which it's allowed or not allowed, hopefully at least not allowed between supervisors and subordinates, you can put a policy together on it. And then I think, as always, training your supervisors so that they know and understand problems that could arise from dating others in the workplace. And so that everyone generally has an idea of what to do if they think they're being harassed or discriminated against. So that's it for today. We hope everybody has a happy Valentine's Day. Don't forget, we've got training resources available. We have our virtual content and law for leaders, and we cover anti-harassment and anti-discrimination in sessions 2, 3, and 4. We have our book, which came out last month, our Law for Leaders book, chapters 5 and 6, including an amazing chapter written by Jennifer Walrath here, cover discrimination and harassment. And one last note is we have our book launch party. If you're here in Boise, Idaho, our party is on March 4th, and you can see the sign up in the episode description or in the show notes. So that's it for today. Thanks for joining us on Ground Rules. Ground Rules hosts and guests are not providing legal advice in this podcast. Do not act upon any of the information discussed in this podcast without first consulting a licensed attorney in your jurisdiction.